So my name is Seth Goldberg. I am a lawyer at the law firm Duane in Philadelphia. And over the past few years, more and more of my practice has become devoted to cannabis because obviously the market for cannabis has grown both in Pennsylvania, around the country, and in Canada. Because Canada is now legal, it's become really a much bigger commercial market. So medical marijuana is really just a part of the overall commercial market. And I'm traditionally a commercial lawyer, so that's why I've been getting into it. But my practice in cannabis has involved lots of business transactions, but I've also been involved in advising some research centers. In Pennsylvania, we have a clinical research program. I've been involved with Thomas Jefferson University a bit. I've been involved with the University of California, Irvine a bit. There's a lot of interest among university researchers in the space because of the regulations that I'm going to cover, and that Dr. Goldman spoke about some of the limited research that's available. There's just not a lot out there yet. But I'm going to give an overview of the federal regulatory structure because it's really important, because the state regulatory structure happens really in conflict with the federal regulatory structure. And so anybody who's going to be dealing in medical cannabis, whether you are a prescriber recommending it, you're a patient taking it, you're somehow working with prescribers and patients who are taking it, and may be in the vicinity of somebody who is possessing medical marijuana, you need to understand sort of what the landscape of risk is. And so that happens with federal or state. Some of what I'll talk about is some of the actual market for the space, and I would encourage you to ask questions along the way. If you have any specific questions about situations that you've encountered, I'm happy to answer them without giving any actual legal advice. It'll all be hypothetical.
Yeah, I'm here.
So from the federal standpoint, it all starts with the Controlled Substances Act of 1970. Marijuana is still a Schedule I drug under the Controlled Substances Act, along with cocaine, heroin, LSD, MDMA, and is considered to have, by the federal government standards, no medical benefits, no therapeutic benefits whatsoever, and it's just a dangerous drug. Later in my presentation, I will talk, and I mentioned it earlier, the FDA has now scheduled CBD as a controlled substance, as a Schedule V controlled substance, which necessarily means that at least with respect to that drug, which we'll get to, there is some health benefit. So now the federal law is in conflict with itself, which we can talk about. But the problem with this thing being Schedule I is there are real penalties if you were to have the DEA, DOJ take some enforcement activity. You can't manufacture, possess, dispense, use marijuana as it's defined under the CSA. But you can also be prosecuted for conspiring to violate the CSA and also aiding and abetting a violation of the CSA. So, if you took it to some extreme examples, could a physician who's recommending it be violating the CSA? Yes. Could a hospital or a center or some facility that's allowing medical marijuana to be taken in its premises, be contributing to the violation of the CSA? Yes. So there's some problems with marijuana being a controlled substance, which creates risk. And I'll talk about the spectrum of risk in a bit. I always cover, I think it's an interesting, most people don't really realize, but I always cover in something like this, just some of the other problems that result from marijuana being unlawful. People who traffic in medical marijuana, even though it's legal, are not just violating the CSA, but they're potentially violating the mail and wire fraud laws, RICO laws. They're doing money laundering. This goes for anybody who's getting paid with the proceeds of cannabis. Potentially people who are paying for cannabis are doing these really bad things. The Bank Secrecy Act is designed to prevent money laundering. And so one of the really interesting things about the cannabis industry is there are no banks that will really bank the states. There are about 8,000 FDIC banks in the U.S. There are about 300 that have openly banked cannabis because they would be violating the Bank Secrecy Act because they're doing money laundering. So most of the state legal cannabis businesses in the state legal cannabis market is a cash business. There are no credit card transactions. There are no checking accounts, deposit accounts. People have to figure out a way to pay tax. The businesses that are lawfully conducting cannabis business, but it's a problem that really infects the industry. And interestingly, it's exactly what the Bank Secrecy Act is intended to prevent. So what happens is the entire industry is really gone underground. It's completely opaque. And the Bank Secrecy Act is intended to create transparency. So the federal government has created this problem by not legalizing marijuana, letting states legalize marijuana, keeping this Bank Secrecy Act to prevent marijuana banking. And so you have a cash business that isn't tracked by the federal government. And as we'll see, it's a pretty big business. It's over $10 billion worth of business in 2018. That's primarily cash, that isn't tracked by the federal government, and presents a lot of public safety risk. So another interesting thing is the tax code, cannabis businesses, and it hasn't been tested in a lot of situations, whether it applies to physicians, whether it applies to rehabilitation centers, whether it applies to hospitals, whatever it is. But there are tax deductions, there are tax limitations because cannabis is unlawful. A cannabis cultivator, for instance, can deduct the costs of the goods to the cost of creating the inventory, but a cannabis dispensary can't deduct its costs. Not pertinent to your issues, but just something to understand. Similarly, because cannabis is unlawful, cannabis businesses can't get trademarks, can't protect their IP, which is a really significant issue, because what you're going to see, we're going to see, is that the cannabis business, the cannabis industry is really becoming a consumer goods market. And so people are creating logos and brand names, and they can't protect their IP, as well as the strains that Dr. Goldberg was talking about. There are now strains that are very high in THC or very low in CBD. These things may be ripe for intellectual property protection, but they can't get it to some degree. Okay, so the industry has grown largely due to an Obama administration memo that was issued in 2013 by then Assistant Attorney General James Cole. And he issued what is now known as the Cole Memo back in August of 2013. And the Cole Memo was about 10 pages worth of policy that basically said the federal government has so few resources to devote to criminal activity that when states have regulated marijuana or medical marijuana and have created their own enforcement regimes for their regulations, the federal government's going to defer to the states. It's going to really prioritize the federal government resources to the really bad actors when it comes to marijuana. And the Cole Memo has set 8 priorities for federal prosecution of marijuana activities, and they all pertain to the marijuana black market. They don't pertain to state legal marijuana. And it's a pretty good solution because we do want the federal government to focus on really bad actors. We want MS-13 and violent offenders and cocaine and heroin and other really, bad conduct to be the focal point of our federal tax dollars. So that's what the Cole Memo did. It deferred to the states, and as a result, it really opened the doors for the state legal cannabis market to grow. We'll see, we're now at 31 states. Probably at the time of Cole, we might have been just a few years ago at 15 states that have legalized cannabis. So it's really grown significantly. And then what happened was about 6 months or 5 months after Cole, the Financial Crimes Network, what's called FinCEN, issued a guidance to banks to try to allow for banks to bank the cannabis space, because that Bank Secrecy Act and the suppression of banking really does create huge public safety concerns. And I'll give you 2 examples. In Humboldt County, California, which is really the source of all natural cannabis growth, there are lots of kidnappings and hostage situations when people are delivering large amounts of cannabis for cash. They don't go reported in the news, but it's because you have this cash business problem. The other day, I was driving by a dispensary, and y'all may have dispensaries now in your neighborhoods, but I was driving by a dispensary on 611 up in Jenkintown. And I noticed that there were orange cones set out on 611 and around the dispensary, and there were guys in black t-shirts standing around, and then all of a sudden a white van with no markings, no windows, came into the dispensary, and it was unloading, it was dropping off, it was delivering, the however many pounds of legal cannabis. But you can imagine the risk that's imposed on these people who are driving from one area of Pennsylvania to another with $1 million worth of legal cannabis in a van. It's just not a great situation. So the other thing that really led to the growth of the cannabis market is this thing called the Goldberg Amendment. This is an amendment to the federal budget, and what it does is it prevents the federal government from spending any money to interfere with a state medical marijuana program. It's limited to medical, and it really is the fail-safe for those people who want to get into the medical marijuana industry. They can do so knowing that the federal government really can't do anything to interfere. And as a result, lots of people get into the space on the medical side only. And they feel like so long as I am dealing in medical marijuana, I'm safe, I can't get prosecuted. And so these things really led to the growth of the cannabis industry over the last 5 years. And as a result, at the end of last year, you could see public approval for cannabis, notwithstanding the lack of any scientific support, is really high. It was at 64% at the end of 2017, and interestingly, it was at about 53% for Republicans. So, and then this year, Oklahoma, of all states, passed a medical marijuana legislation. So it's really, you're at 31 states, obviously a number of those are red states, but it's really supported by public opinion. So when Trump took office, everyone in this area who's in the cannabis industry thought he could go either way. Surprise. I mean, he had indicated support for cannabis in his candidacy. It really is a populist issue because it's so pro-business. It's one of the very few emerging markets. But Jeff Sessions is very, very anti-cannabis. Not just because there's maybe not a lot of scientific support, but he just thinks people who get high are not good people. And so he had, for a while sort of stood on the sidelines, and then on January 4th of this year, issued his own memo, the Sessions memo. And the Sessions memo rescinded the Cole memo in its entirety, leaving, taking away the 10-page Cole memo for a 3-paragraph Sessions memo. And it basically said, we're rescinding all previous guidance with regard to marijuana. Federal prosecutors are now encouraged to use their discretion to determine whether or not to prosecute state legal cannabis activities. And really focused on the financial part of the market. And his memo was clearly driven at stifling the growth of the cannabis industry. It wasn't really targeted at the fact that maybe there's not enough research, or maybe there should be fewer medical states or fewer adult use states. There was nothing really behind it except the fact that it was really growing from a financial standpoint. And his memo, the first paragraph, which focuses on money laundering, unlicensed money transmitter statute, and the Bank Secrecy Act, was a warning to those people who were investing in the cannabis industry to stop what they were doing. So that was January 4th of this year. And one thing that has sort of become clear now that we're 3/4 of the year in is that really things haven't changed, because the 8 priorities of the DOJ under the Cole memo were really targeted at public safety. We want the bad actors to be the focus of our federal enforcement dollars. And the civil levy principles, which were referred to in the Sessions memo, these are the principles that guide U.S. attorneys in something called the U.S. Attorney's Manual. They're also focused on the bad actors. So the federal government in 2018, notwithstanding the change in administration, the change in approach, the federal government has done nothing to crack down, so to speak, on state legal marijuana activity. And there hasn't been a single enforcement against state legal cannabis in 2018. So the industry has continued to grow at a pretty robust pace.
And so the Office of Justice, they're just ignoring what Sessions said?
No, what Sessions did was he gave to the U.S. attorneys the discretion that they always had. U.S. attorneys in every jurisdiction have the discretion to decide whether they're going to take some enforcement action in their jurisdiction, and it really depends on public safety. So you can, public safety and public opinion. So you can imagine that a U.S. attorney in Denver is not likely to go and crack down on all of the cannabis cultivators and dispensaries in Colorado and Denver. It would be a very unpopular decision. And when weighing that unpopular decision with the public safety concerns, state legal cannabis where the states can regulate versus, black market cannabis where people are really doing bad things, they're carrying weapons, they're doing crimes. Most U.S. attorneys are going to focus here on the really bad actors.
Just recently, I forget if it was Beaver or Butler County, we're hearing that eviction notices have been sent to medical marijuana card carriers who are recipients of HUD housing assistance. Have you heard of that?
Who are recipients of federal housing assistance.
Yeah.
I haven't heard that, but it doesn't. It surprises me and it doesn't surprise me. I think depending on where you are in the country, that could be an issue, because generally, this is really a concern for anyone who is in a business that accepts federal funding, any individual who's taking federal funding, and also involved in state legal cannabis, is generally the federal government doesn't like to fund people breaking its own laws. And so it usually says, well, we're going to cut off any funding for something like a violation of the Controlled Substances Act. It can civil forfeitures can take away property if you're violating the Controlled Substances Act. Civil forfeiture is one of the penalties under the Controlled Substances Act. But it may be, and so one of the things that I advise my clients who are in this space, that folks who are really involved in this space have to keep an eye out is, what's the temperature in my jurisdiction? And what's the temperature of the authorities? I'm in Philadelphia. The U.S. attorneys in Philadelphia, again, it would probably be an unpopular decision, and they generally have more important things to do with their federal dollars. And they can say, you know what? The state legalized it, the state regulates it, let the state deal with the state legal cannabis, and we'll deal with the black market cannabis. It's not to say the federal government has not turned a blind eye to cannabis. It's just prioritizing state legal and black market cannabis, which is not a bad thing from the public standpoint. So this year we just had some different things happen with respect to federal regulations. The Treasury has said it's going to change the banking regulations. It hasn't done so yet. Rohrbacher has been renewed. I actually, as of today, don't know. I don't know if it's going to be renewed again, but I expect it will. It has been renewed since 2014. There have been two bills that have been proposed with respect to medical marijuana, one by Colorado Senator Cory Gardner and Massachusetts Senator Elizabeth Warren, which is a bipartisan states' rights approach, which basically says, federal government, you stay out of our marijuana business. That is pending, and Trump has said he would not veto that. So if it were to actually make it out of committee and become a passed bill, he wouldn't veto it. And Chuck Schumer proposed his own legislation decriminalizing cannabis. Both bills are really kind of stalled. The committees haven't moved on those bills. We haven't seen any change with respect to banking. But Trump himself has come out this year a few times and said he would support the states' rights approach. So the industry is still growing. Here's just a sample of some of the things that I find interesting in this space. 31 states and the District of Columbia have medical marijuana. 9 states and the District of Columbia have adult use marijuana. You can see the size of the industry. It's an industry that's fueled by capital markets, lots of investments. Canada goes to adult use nationwide next week. And that is a really significant event, really from the adult use and the medical marijuana market, because there's just so much private capital in Canada. Now it's public in Canada. It's our northern border across the entire country. There's lots of commercial activity, lots of cross-border transactions happening now as people are trying to invest in the Canadian market. Canadians are trying to invest in the U.S. cannabis market. And, it may have, it may have an impact more on public support for cannabis as people, at least on the northern part of the country, really become used to the fact that the northern border cannabis is completely legal. And medical marijuana is legal in Mexico. So we're sort of in the middle there. It is a really robust industry. There are all kinds of different businesses that feed in and out of the industry that are non-cannabis related. A huge piece of it is biotech, biopharma, and medical and clinical research. Epidiolex, which Dr. Goldman talked about, is made by a company called GW Pharmaceuticals. They are also making Sativex. They're one of maybe 15 very large, GW Pharmaceuticals is not Teva or some other really, really big company, but it's big enough and they've got a lot of capital to put into the industry. I've seen projections that the medical marijuana market, if the recreational is worth 50 million or 50 billion, the medical marijuana market is worth another 50 billion. So it is just a huge, huge market with lots of potential for different drugs to be made. So I want to just talk about CBD because this is the most confusing part of this industry. And I can't talk about the science except to say I do know it's not psychoactive, right? And so you see CBD all over the place now. You're going to start to see it in Walmart and CVS. You're going to start to see it in any kind of health food stores, Whole Foods, whatever it is, and they start to sell CBD because it's really being marketed, because it's not psychoactive, it's being marketed as almost like an herbal supplement, a dietary supplement, but it's not. It doesn't fall within a dietary supplement definition under the FDA's rules. The FDA did approve CBD as it's contained in Epidiolex, and only as it's contained in Epidiolex. And it's scheduled it, as I mentioned earlier, as a controlled 5 substance, which means there's some recognition that it provides a health benefit. This is what the FDA said just on Thursday of last week in announcing the controlled 5 scheduling of CBD. Marijuana and CBD derived from marijuana remain against the law, except for the limited circumstances that it has been determined there is a medically approved benefit. In those instances, such as here, so in this instance there's a medically approved benefit, the drug will be made appropriately available to the public for medical use. So it really begs the question, how are all these people marketing CBD? You see CBD lotions, CBD pills, CBD honey, CBD lipstick, and you can see it.
Whole Foods has a whole line.
So it's over the counter? I mean,
It is.
It's not an over-the-counter, okay? It's not an FDA-regulated over-the-counter supplement. So how is it doing? There is, the way this works, and it's really complicated, there is a definition of marijuana in the Controlled Substances Act. It's defined, it's like a 15-sentence definition of what marijuana is. And then there is a footnote of what marijuana isn't. And what marijuana isn't is part of the plant, the mature stem of the plant, the sterilized seeds of the plant, oil and cake made from the sterilized seeds of the plant are not, quote, marijuana. And there's enough in there to say, okay, well, maybe I can take CBD and I can manufacture CBD using the non-marijuana parts of the plant. And if I can do that, I am not breaking the law because I'm not using marijuana. I am using the part of the plant that's been accepted from the definition of marijuana. The problem is, at least from the DOJ and the FDA standpoint, is there's no way you could actually make something that has therapeutic benefit from those parts of the plant that they've accepted from the definition of marijuana. The CBD that comes from the flowers, the buds, the things that people smoke, that's the stuff that's in Epidiolex. So what is likely happening is people are breaking the law and they're manufacturing CBD products, and either they are knowingly using parts of the plant that are marijuana, and we know that happens, or they think they're using what's called industrial hemp. They think they are using the stems and the stalks, and they think they've actually found a farmer in Kentucky who's growing hemp, which is a type of the cannabis plant. It is not the same part. It is not the same plant that is marijuana that is used for medical and recreational marijuana. Industrial hemp is a different plant altogether. It looks different, and it has different applications. We've all seen hemp fiber bags and hemp clothes and hemp soaps and things like that, and that's all really great. The reality is it would take so much hemp to make enough CBD to put in one bottle of Epidiolex. So somewhere the rubber is hitting the road somewhere with people likely breaking the law. And the way the FDA has approached it is to say, we're going to put the onus on the manufacturers. So beware, if we come knocking on your door, you're going to have to demonstrate that your CBD was sourced from the parts of the plant that are not marijuana. The DEA has really not been that interested in CBD. It's really left it to the FDA. The FDA has looked at CBD from more of a labeling standpoint. Those people who put CBD on their products at Whole Foods, if they say cures cancer, then the FDA is going to have a problem. If they say it makes a nice makeup or whatever, then it won't be a problem. But Dr. Goldman, I know you're trying to get out. Okay.
Thank you again. I'll talk to you later.
So the people who are, the Whole Foods of the world and the consumers of these products are also breaking the law, but they're not really the focus of what the federal government is. Okay, so quickly turning to Pennsylvania. The bill, the Medical Marijuana Act, was passed in 2016. Pennsylvania was the 24th state to legalize for medical purposes, and at least when it was passed with specifically in contrast to the Controlled Substances Act. The Pennsylvania legislature believes there's some reason to think that it could be potentially therapeutic. It'd be interesting to have Dr. Goldman, how they got there and what medical researchers think, maybe in conflict. But in any event, the state legislature passed it. It is a Department of Health program. The department created what's called the Office of Medical Marijuana, which, in talking with the Office of Medical Marijuana and hearing them talk at the Pennsylvania Health Law Institute earlier this year, it clearly has become the biggest department or office within the Department of Health. It is a very robust program. If you haven't yet, and you'd like to learn about what this program is, if you go to www.pa.gov, that's the Pennsylvania website, you'll see a link to the medical marijuana program. You can get all the information that I'm going to give you, plus all the much more fulsome and better information on that. It talks about how you get a caregiver card, how you get a patient card, how you find a dispensary, how you find a doctor, etc. I'm going to go through some of that. But the website is really, from a government standpoint, has definitely changed the way the Pennsylvania Department of Health does its work. It's a really robust program. The office issues permits for growing, processing, and dispensing cannabis. It issues the patient certification cards, the caregiver cards. It issues the physician registrations, has developed training courses for physicians, for nurses, for pharmacists, and is really something that's continually being improved. Sorry, but I couldn't fit 21 conditions any bigger. It's like a Dr. Goldman slide. But here are the 21 conditions that are qualifying conditions. In order to get a card, you have to have one of these 21 qualifying conditions. I bolded a few, and these are the same that Dr. Goldman really focused focused on, but you know, opioid use disorder was not one of the original 17 conditions. It was added in May of this year. Post-traumatic stress disorder, severe chronic or intractable pain. So I'm not going to get into the science, but I will say that from a industry standpoint, these two are really why the industry is so big, because people use these as their way to get medical marijuana. I mean, it's not rocket science to think that somebody would use, say, you know, it's a lot easier to say I got post-traumatic stress disorder symptoms than Huntington's disease or whatever it is. So, in any event, but the opioid use disorder is an important one. Again, there are lots of different ways people look at this industry, and you guys are all specialists in what you do. But in terms of how the industry has justified itself over the past few years, especially with respect to the Sessions memo, being able to say it is an alternative to opioid use has been a very compelling argument to at least expand the research of medical marijuana, to expand the use of it in some states. It's a great justification, if you're looking for one, to have more research in the space. So those are the 21 qualifying conditions. Pennsylvania, when it first enacted the legislation and the program first came online, did not have dry leaf. You could use it only as a pill, oil, a topical, vaporized, vaping, nebulization. Okay. The big thing is, so when it first came online, because it didn't have dry leaf, it was very expensive because pills are much more expensive to make. Vaping is very expensive, and so the state added dry leaf to address the concern that people really couldn't get the benefit of the drug because they couldn't afford to use it. So now, dry leaf has been added, and dry leaf means it can be smoked. Well, it can be vaped. You can put it into a vape cigarette. So now it can be combusted in a vape pen. The thing that I think is a concern of Dr. Goldman's, and a very real concern, is that the cannabis industry has really done a great job of creating a very potent drug. It is not like, you know, I think Dr. Goldman, she found, she refers to 25% THC. Well, you have products on the market that are now 90 to 95% THC. It's like you're almost getting that pure THC from Marinol. You can now buy in a dispensary. In the states where it's adult use, that is really prevalent. There are these products now called butter or shatter or wax, and they're almost pure THC. So if the addictive potential is as significant as Dr. Goldman suggested, you know, maybe this industry is really self-defeating because it's just creating one set of, substituting one addiction with another. Here's the physician registration information. Right now there are at least 860 physicians. This was as of August. 860 physicians in Pennsylvania have registered to recommend cannabis. Physicians don't prescribe cannabis in Pennsylvania. They don't prescribe cannabis anywhere. What they do is they make a recommendation. So in order to get your physician to be able to recommend marijuana, they have to register with the state. Their ID goes on a registry, which has been a reason some physicians have been reluctant to register because they don't want to be associated with registering and recommending medical marijuana. They have to, there are the regulations control how they can recommend. So you were referring to a patient earlier, a physician has to certify that they are following the patient. It's not simply, I'm going to go to a doctor, get my prescription for medical marijuana, and never see the doctor again. The doctor has to certify the patient. The patient can't get certified unless the doctor certifies the patient as having a qualifying condition, and that the doctor will be following the patient for the course of treatment.
Where does that part say things? I guess that's the part that, the certification is what I understand. It's the other part that's disconnected at the moment,
What do you mean?
that they must follow.
So it's in the regulations. Now, how these things happen in practice probably vary greatly. And I could, California is a great example. California has had medical marijuana since 1995. It has had regulations controlling medical marijuana for 30 years. And it is basically a one-stop shop. You can walk into a dispensary. You can get a card from a doctor, from any doctor, and go into a dispensary and get it treated. And this state, maybe some doctors are issuing their certification and they're not really following the patient, but they should be. You can't necessarily control it, because what happens is physician certifies the patient applies to Harrisburg to get a card, patient gets the card, and I'm going to go through this, and goes to the dispensary where the physician is not. And there's a pharmacist at the dispensary who then says, I'm going to give you X product based on the recommendation. How it goes from there, who knows? But patient would need to go back to the doctor to get a renewed prescription.
You might have just said what I've been told is that there's an annual recertification process.
Yes.
Is that right?
Correct.
And I've also been told that there isn't necessarily there could be other people treating the condition at hand, and also the patient doesn't, they would not necessarily need to have consent to.
Yeah,
discuss that with others.
there's not the coordination that you would expect. I mean, when a patient is prescribed a narcotic, they go to Walgreens and get the narcotic. The physician can see into the same system that Walgreens can see into, so everybody's tracking the drug, what the patient's doing, how the patient's taking it, etc. The physician can say, I gave you this 2 years ago, I'm going to change, we're going to change. That doesn't happen with marijuana. That's not part of the way the system works. So the physician that makes the recommendation to the patient, he can be one of the many physicians the patient's seen. If somebody is suffering from migraines, let's say, maybe they've been going to a neurologist and taking drug after drug after drug, and the migraines have not subsided. They could find a doctor on the registry who's a neurologist and go to that doctor and say, I want to try medical marijuana. You're a neurologist who's registered to do it. Here's my history. I've clearly tried all these drugs. They don't work for me. Maybe the doctor says, okay, I'm going to prescribe medical marijuana. I'm going to certify that you have migraines isn't one of the list, but maybe he says chronic pain. Chronic and intractable pain, certainly migraines fall within that definition. And so can treat that, can become a prescriber or a physician who's treating that patient, and that should be enough for the patient to then get the certification and go get the medical marijuana. And then if the patient wants to get a new prescription, go back to that doctor. Doesn't necessarily need to say to his or her neurologist who's not prescribing medical marijuana that I'm doing this, that I'm taking this. It can just be done on the side. And the physician, as I mentioned, the physician, even though they get a 4-hour training course by the state on kind of what cannabis is, they don't, and they can't prescribe a specific strain. They can't prescribe, maybe their prescription can be high CBD, low THC. They can prescribe the duration of use, 30 days, 15 days, twice a day, but it's really left to the pharmacist at the dispensary to choose the product.
So the physician certifying does write a prescription?
Writes a recommendation, yes.
Are they opening themselves up to all sorts of liability if they don't follow that patient they've recommended?
Yeah, I mean, certainly they would be violating the regulations under the Act. And to the extent that that creates any other liability, it probably doesn't create, quote, malpractice liability. Because I don't know that the regulations are intended to create a duty of care standard. They can be looked at as a duty of care standard. But, whether they follow or not, probably doesn't, I don't think that was the intent of the regulation, to create that standard.
I don't think there's much intent or understanding at all.
Correct. That's probably right. I mean, I don't think this piece of the medical marijuana regulations was really well thought out. I mean, it should be as controlled as any other, right? I mean, as any other narcotic. This is a controlled substance. It should be tracked as such. Yeah.
So, just as an aside comment, I mean, for those things that are FDA approved in our ability to use them, they have to reach a higher standard very often with prior authorizations for all of us and the families. I'm concerned just about then, so if we wouldn't anticipate that malpractice insurers would be covering this part of somebody's practice.
So that has to, malpractice insurance, all areas, all lines of insurance are really in flux with respect to this space. There's probably an exclusion under a malpractice policy for doing something unlawful, prescribing something that's unlawful, right? Or prescribing an unlawful drug, off-label, whatever it is. There are certainly exclusions under medical malpractice policies. Carriers will use those exclusions. The question is, and we haven't seen it, it has not been litigated yet, that question.
So I guess a follow-up to that, then when we have very much an awareness that this is part of what is going on for a family, and we're prescribing to, and what's our liability in terms of barriers?
Well, I mean, I do think that I think the insurance industry is a big question mark right now. In fact, I'm going to speak at the American Insurance Association next week on this issue because they're really trying to, some insurers want to get into this space. They want to write the lines of insurance because they see this as a huge opportunity. Some carriers want to figure out should I be relying on exceptions here? It hasn't been litigated yet.
Yeah, I was wondering, 860 registered, and I know a lot of physicians
Yeah.
who have lots of questions and hesitations. A few that maybe would like to get the training and have the occasional patients that, that they
Right.
would really, it's their patient, and they want to have all options available. It's the
Mhm.
best case scenario in a way. But they don't want their name on a registry,
Right.
a public registry.
Yeah.
I heard that piece of the law was maybe going to change or did already.
I don't know if it has
Okay.
changed yet. It has been raised as whether a physician has to be registered, has to be on the public registry or not. It does raise a question.
And is that a limiting factor in things? That's,
Certainly.
the number being small, is that considered a small number? Or are physicians jumping on board to get registered? Compared to registered?
I don't know how to answer that question. It seems to me, this is really since this year. I don't know how to answer it. You can look at the list and you'll see that they're from all over the state. But if that law has changed, and I don't know if it has, because the last time the board met was in May or June, they added conditions, but I don't think they changed the registration policy, that it has to be publicly disclosed. If they did change it, and these are the publicly disclosed, there could be more, but I don't think it has.
So I heard, you mentioned like the banking industry, and you mentioned like checks and being a cash business, which my understanding too is that no insurances will cover, because insurance is a federally regulated industry.
Correct, so people can't get,
Right.
that's why the controlled substance, the scheduling Epidiolex as a controlled 5 is important, because now, at least for that drug, it can be covered. So that was an important decision by the FDA to make sure that it was a covered medicine. But yes, you're right, it's not covered. One thing that's happening, just while we're on the topic of insurance, is that it is being covered by workers' comp plans. So if you're a worker, you get injured at work, and you then end up having to treat with medical marijuana, the courts have come down and said, carrier, you've got to cover this. And the reason, it's fascinating to read some of these decisions, but a lot of it has to do with opioid use. Because the courts are struggling in this circumstance to say to a carrier, look, I've got, and there's a case in Maine, which is a really good case on this. There's a guy who he got injured at work. He was prescribed opioids. He was horribly addicted to opioids. His workers' comp paid for the opioids,
Yeah, absolutely, yeah.
right? So he was able to fund his addiction for years, and it was debilitating. The addiction was keeping him out of work, not the injury. So he wanted to get onto medical marijuana and mainly medical marijuana. And this issue was litigated, and the Maine court said, carrier, you have to pay for this. And so it's really in flux. I mean, this is one of the neat things, is that we're sort of doing this in real time. Pennsylvania courts haven't decided any of these issues. But they may, yeah.
Is there any talk or work like backing up and going on the front end? I have a son who's in college and he sprained his ankle last year. So he went to the clinic at the university and the ER doctor prescribed him Tylenol with codeine. And I'm on the phone going, you got a sprained ankle, dude. Go home and take 3 Advil. You're not taking that prescription. So thankfully he told me, but we created this environment that it's okay to give these heavy narcotics to young people and start the process and down that path of where young kids may not even entertain the thought of that or even taking it. So what kind of proactive steps are happening in our industry to try to change that mindset. It's such a moneymaker, you know, between the pharmaceutical companies, the
They're-
doctors,
right.
like, I mean,
When you say in our industry,
yeah,
what industry?
in the healthcare industry.
In that- So, in the healthcare industry, is one thing. In the cannabis industry, there's, you know, very little that's being done to sort of be proactive about the potential for use, because the whole thing about the cannabis industry right now is trying to grow. It's trying to legitimize itself. It's trying to say, hey, we you know, look at all this anecdotal evidence of health benefits. I mean, very few people in the cannabis industry are trying to. You know, the regulations prevent cannabis from being marketed to minors. You can't have colorful advertising. You can't have images and graphics that are designed to attract minors to cannabis, to state legal cannabis. The dispensaries, they are you know, pretty much very generic looking, very subdued. They can't advertise. They can't have windows. They don't. You wouldn't know that marijuana is being sold there. So the regulations try to build in some protections.
You asked about the healthcare, what the healthcare industry is doing. I mean, one important thing is we have the PDMP, so that actually allows you as a physician, when you're about to prescribe something which might have addictive potential, use stimulant, something that you can abuse, you can check to see that they're not doctor shopping, they haven't got it from somebody else, and you can actually therefore regulate and make sure what your client is actually taking. So that is one step. And hospitals individually are getting some guidelines now for their ER doctors, saying do not give more than a 7-day supply. And dentists as well are being asked to actually really limit their prescribing. So it's not law, but there's some suggestions coming out.
Well, I think it's scaring a lot of folks in the pharmaceutical industry. I was just at a conference late last week where the Attorney General Shapiro was talking, and you know, he basically said, we're in a place now with this that I really can't talk to you in great details, but I can tell you right now, the state of Pennsylvania, and there's a whole truckload with us that are going after the pharmaceutical companies. And so I think that's going to help some. I do think keeping the docs, just as you said, I mean, I know just my mom was 84 and trying to get her doctor to stop giving her all these opioids, and I finally threatened him, and I just said, you don't understand. My mom can't function on these things. If she falls again and she dies, I'm going to be back to see you, you know, and I'm not going to be alone. But, you know, his response was, I treat your mother. Your mother is my patient. Basically saying, I don't care what you think. But guess what? You know, I mean, unfortunately, you know, that's not what ended her life on the planet, but I think they are getting scared. I think docs are starting to realize, and it's kind of having a swing effect, because now we have some people who really do have horrible chronic pain. They have a hard time getting anything because the doc is so afraid to, you know, because
I think though that that's a really varied experience, because as a person who presents with a very obvious physical condition and is seen a lot in emergency rooms and doctors' offices, I have to say, I don't want opiates. I have a codeine allergy. I have problems with opiate medication. And, well, then why don't you? Or there's nothing else we can do for you. I can walk into an ER and get a 90-day prescription for Vicodin, where my other half can go in. It wouldn't matter if he had a bullet hole in his head, they'd probably write him 3 pills and tell him to go up. So there's a very uneven balance to the scales based on what doctors perceive as a person's experience of pain. And I think that's really unfair, and we need to do more to correct that.
And now, of course, since Dr. Levine's major statement about treatment, you know, we're, like I said earlier, our members are really struggling with, you know, how do we deal with this? Like, even if we're talking about a methadone clinic, I mean, we have all these best practices for providing medication-assisted treatment, in particular methadone. And everywhere it says you've got to test for all drugs, and you cannot tolerate for a minute your client being on other, other drugs. And, but now it's just, yeah.
I'm sorry. My question is, Dr. Goldman had, she suggested that certain conditions, bipolar or psychotic conditions, would not be eligible for medical marijuana, but that's not a legal, is there legal language for that, or is that simply more a discretionary issue?
Well, sir, you have the 21 qualifying conditions, and that's the legal limitation. So if you can, if it's not on there, you can prescribe for it. Now, that gives, I guess, physicians some discretion in how maybe.
Yeah, but I'm trying to say, so that you have a schizophrenic who has chronic pain.
Right.
If they go for chronic pain, they can get medical marijuana even though they are schizophrenic.
If the physician hasn't diagnosed or the physician isn't aware of that diagnosis.
Well, let's say they are aware that there's no legal mandate.
There's no,
You're
right.
not allowed to
Correct.
do
Well,
that.
and she
Correct.
actually said they get worse. She
Well,
actually talked
and I
about
understand
that,
that.
for some different disorders, it
Correct.
it
So I
actually
wanted to-
causes psychosis.
I wanted to make sure I just heard it, and the language is that, yes, if that's schizophrenic, whether that person, doctor knows he or she is schizophrenic or not, he could still choose to give medical marijuana to
There's
that person.
nothing restricted, there's nothing.
That's what I'm looking at. There's nothing legally that restricts them, and there's no formal statements that say you cannot do this.
Yeah.
I think that's right.
Yeah.
And then we have that with, there is this disconnect with how we collaborate and communicate. That I think that right now, my experience is that there's a complete disconnect between the person that is certifying and moves them on with the card and what I'm doing with them in my office. Or what the primary care physician is doing, because I think there might be 3 of us or 4 of us or more involved in this person or this child's care, and nobody's talking to anybody, and nobody alerted us that this was happening.
But even if you speak to the chronic pain specialist and say, this person's schizophrenic, that person could go, yeah, but I think his pain's worse than, I'm going to take this chance. And there's nothing you can do except for, I guess, choose to not treat them for their schizophrenia.
Well, I would liken it, I guess, at this point to, I have a young person that is going to have to, that is on a list for a renal transplant. And they do have schizophrenia. They're going to probably be exposed to steroid treatment post-op. And that's not a good thing for this young person who has a mood and thought disorder. But we're going to, you're a rock and a hard place. And so some of these things are a rock and a hard place. It would be better if we would communicate with each other. That there would be some kind of way.
Somebody's going to get hurt. Well, people are already getting hurt.
Yeah, I represent several providers who are having, inpatient, and they're being asked to administer medical marijuana. What risks are they facing in terms of federal funding? Have you seen any?
Yeah, so. The risk, so the way I look at it is there's this spectrum of risk. When you're dealing with medical marijuana or legal marijuana, and somewhere those prescribers or those physicians fall on it. But at the very low end of the risk are the families who are treating their epileptic child with Epidiolex or some other legal marijuana, state legal marijuana. Very low end of the risk. You would think that the federal government is not about to, walk into somebody's house and deal with that use. And the other end of the spectrum are the violent criminal offenders who are dealing in black market cannabis. Clearly, that's where the federal government is targeted. But then you've got, in the middle here, you've got, this range. Are the people that are growing the state legal cannabis, they seem to be more on this side of the spectrum of risk than the physicians who are prescribing it to these people, right? So there's no answer to the question. I mean, there's no easy answer to the question. We haven't seen any federal enforcement activity. We haven't seen anybody lose their federal funding. We know that physicians at major universities have now registered. Those universities are getting federal funding. Medical marijuana is not being doled out at university hospitals. We're not seeing the pharmacy at Penn or the pharmacy at Hershey in the hospitals not carrying medical marijuana, so federal funding isn't at risk there. But, it's very hard to predict. There's no precedent for the federal government going and knocking on the doors of physicians who are prescribing state legal cannabis to patients who are certified to use it. It's really the black market that is the problem. Yeah.
I'd like to go back to Dr. Alba's dilemma. If a patient comes with a card and pre-certification for one of the 21 qualifying disorders and a recommendation from somebody else for medical marijuana, is it within, well, it is within the purview, but what would be your response if the physician who did not make the recommendation says, I'm sorry, the person who made this recommendation is not following you, and that's not me. I can't help you.
Well, the physician, the treating physician, I don't know what the treating physician would do in that circumstance except to say to the patient, I don't support your use of medical marijuana. I don't think you should use it. But I don't know that the treating physician would have any recourse or anything to do except maybe go to the Department of Health and say there's a physician out there who's prescribing medical marijuana in a way that they shouldn't be. And that is something that can be done.
Dr. Chapman had mentioned the prescription drug monitoring program. Do the pharmacists and the dispensaries have to post that and that information in there? So no, there's no way of knowing. I didn't think so, but I wasn't sure.
I just have a question, which is a little bit off topic probably for most of the people that are here. But we support people in the community in a group residential home. And I'm now being approached by a parent who wants us to take their child with epilepsy who is taking what she calls hemp oil. Has anybody else had that experience?
Yes.
Or in a
Yes.
direction? And what do you do?
Well, my experience so far has not been within the context of a residential program, but it's probably just a matter of time. But in the outpatient clinic, there's plenty of folks right now that are going to the Whole Foods market and getting their hemp CBD oil
She
and
gets hers from Colorado.
or on the internet.
Yeah.
And at the moment, I guess how I've approached it is trying to educate them as to this is not something that has anything behind it in terms of research and data, and that you are giving a supplement that is not regulated, and you should be setting up if you weren't doing this, what is it that you're trying to achieve, and how are you going to track it, because you're going to be responsible for it, and so what's your goal, and how are you measuring it, and you're doing a little
And you
research
don't even know
project.
what's in it.
You don't. You
That's
have
the
no
other
idea.
thing that's
You have no
really
idea.
scary, I think. You don't know what's in it.
Correct. Correct.
All true. And it's illegal.
It's illegal.
Right? And it's potentially illegal. But if it's CBD, if it's hemp oil, and it goes back to that slide I had where people are, CBD is this tricky question.
Right.
And if it's on the premises, then potentially the landlord is now, and the owner of the premises is now liable, especially if it's knowingly owned.
So as a provider organisation, I think really you have to come down on the side of safety. So I work as a medical director for a large behavioural health agency, and we have lots of residential programs. And we've taken the decision to not allow medical marijuana in. So if someone wants to come to our residential treatment facility, we say, sorry, you may come, but you may not bring medical marijuana. And we'll say, if you bring it on, it could trigger other people who are in recovery. We give them a few reasons, but also these are voluntary programs, so they have a choice to not come. But it seems to us to be unsafe to actually allow medical marijuana into our facilities because we are federally funded, as most behavioural agencies are.
That's a view of risk managers around the state. I mean, it's a really complicated question because you're there, you do want people who are getting some benefit from it, especially a kid who's treating it for epilepsy. Maybe they are getting some benefit from it. How do you say, well, while you're here, you're not going to be able to get that.
But that scenario in the drug and alcohol field, we've got a Surgeon General, Secretary of the Department of Health saying, absolutely, you should use marijuana to treat opioids, people struggling with opioids. And I just think, anyway.
Aren't we
I'm
as
just so upset about it.
providers setting ourselves up for a potential lawsuit if we say no?
Oh.
Well,
There goes.
I don't mind.
Yeah.
The suit can fall in any
Well, I'm just curious, I mean.
I don't know, it
is that
depends
just a
on,
matter of time?
it depends on what the lawsuit is. I mean, I really don't think you're getting into some area of medical malpractice, for instance, to say, no, you can't have it here because it's against the law. I mean, you've got a pretty good defense, which is to say, the substance is against the law. You're not prescribing it, and you don't have to, at least from my standpoint, again, I'm not giving anybody legal advice. You don't have to expose yourself to federal, to breaking federal law. How can that be the basis of a lawsuit that, hey, there was a patient who was treating with a federally banned substance?
I think another piece of this is, I don't know, perhaps this was maybe part of the family, is just trying to remove barriers for care too. And for those family members that are individuals who are recommended for medical marijuana and are in need of our services, to maybe try to think like outside the box.
So here's
around some of these things.
Here's outside the box thinking, okay?
Yeah.
And we've got no time.
Got it.
One way to approach this, okay, is if I were a risk manager, one way to approach this would be to say, I'm going to call my carrier, and I'm going to make sure that no matter what, if I have this stuff on my premises, if my practitioners are prescribing it, treating with it, if I'm allowing patients to use it, am I covered? Am I still going to have insurance? I want to know that first. Okay, thinking outside the box. And if my carrier said, absolutely, we'll amend your policy. We're not going to have an exception. We're going to do something. We're going to give you our guarantee that we're going to cover this to a limit. I mean, maybe it's not, maybe there will be some modification, but I want to know that. Maybe I'd call my bank and say, look, is this going to trigger any sort of problem with my bank, with my loan, whatever it is, if I have federally banned substance on my premises? If I've got those two things covered, now I can pretty much do business with this stuff. What is the concern from a provider who's regulated by the state? Is the state of Pennsylvania going to take any action against me? Probably not. This is their program. Okay, so now I don't have to worry about state enforcement, I don't have to worry about my carrier, and I don't have to worry about my bank. What do I have to worry about? Federal funding. What is the chance that I'm going to be the target of a federal enforcement mission, my operation. That's as good, that may be as good as you can do, right? You may be able to sort of winnow down the risk until you get to that question of is my organization a target for federal enforcement? If it is that a risk I can take? Am I willing to lose federal funding? Is that a risk I'm willing to take? But as long as we have that federal prohibition, you can't eliminate the risk entirely.